The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon, everyone. The next case is Ashley Deminski as guardian ad litem on behalf of CED, EMD, and KAD versus State Board of Education and the Pitt County Board of Education. We'll hear from the appellant.
Mr. Chief Justice, and may it please the court, my name is Troy Shelton, and I represent the Deminskis in this appeal. I'd like to reserve 5 minutes for rebuttal. This is a case about the constitutional right to access a public education. The people in this state have promised that every child will have equal access to a public education. And that right of access is crucial because even the best quality curriculum is worthless if a child doesn't have access to it. Here, the Deminski children were denied access. They were subjected to outrageous abuse while the school stood by and did nothing. That kind of deliberate indifference violates the state constitution. On appeal, the school board has taken an extreme position. The school argues that it is free to deny access to an education for any reason, good or bad, and that this court is powerless to review it. That argument defies the plain language of the state constitution, the precedents of this court, and common sense. We ask that this court reject the school board's arguments, reverse the Court of Appeals, and remand for further proceedings. To answer the question before this court, there are 2 steps. At step 1 is a question of constitutional interpretation. Does the state constitution protect an individual student's right to access a public education on the same terms as all other students? We believe that the plain text of the Constitution and this court's own prior case law has already clearly answered that question in favor of the Deminskis. At step 2 in this case is a question of constitutional construction. If there is a right of access, how should it be enforced in cases of peer abuse? In other words, what is the standard? We have proposed the deliberate indifference standard as the method of applying that right to this case. The school board has not engaged with that standard, nor has it offered any alternative. Turning to step 1 of our argument, the Constitution protects an individual student's right to access a public education on the same terms as all other students. Turning to Article 9, Section 2 of the state constitution, there's a guarantee that there will be free public schools and that all students in those schools will have a right to equal opportunity to access in those schools. This provision, of course, speaks to the General Assembly's responsibility to provide access to a public education. But just because the legislature is required to provide the access doesn't mean that other government officials can interfere with or deny that access. The Law of the Land Clause, sometimes called the Due Process Clause, limits every actor that's been clothed with the power of the state from depriving a citizen of his rights or privileges. And of course, one of those rights and privileges under our Constitution is the right to access a sound basic education. Therefore, reading these clauses together, they are fairly interpreted to mean that the General Assembly must provide access to a public education, and that all government actors are therefore prohibited from interfering with or denying that access. This court's own case law confirms that simple interpretation. In Snead in 1980, this court addressed a case that had been filed against the Greensboro Board of Education. There, that local school board had adopted a schedule of fees that it was going to charge students. And the penalty for not paying those fees is that the school would deny the student re-enrollment. The school board in that case conceded that if it denied access to a student that was financially unable to pay those fees, then that would be unconstitutional. Although the school had a fee waiver policy for poor students, it was vague and it wasn't actually provided to the students. The court held that the enforcement of the fee schedule in that case against poor students violated the Law of the Land Clause and the Equal Opportunities Clause in Article 9. The school's enforcement of its policy, this court explained, engendered an unnecessary obstacle to the constitutional right of equal access to the educational opportunities available. And the key takeaway from Snead for this case is that the Law of the Land Clause, in combination with the educational provisions of our state constitution, limits the power of local school boards to deny students access to a public education. It's worth pausing there because the board's counter arguments in this case focus entirely on step one, whether an individual right of access against the school board even exists. First, the school board argues that because the state has the right to provide access to a public education, only the state can be sued. The board seems to be relying on the Leandro line of cases for this argument because in 2018 in Silver, this court held that the state has the obligation to provide a sound basic education. But that argument makes little sense in a case like this, where the allegation is one of an access denial. It's the law of the land clause that prohibits all government officials, including local school boards, from denying fundamental constitutional rights.
So Mr. Shelton, just to make sure I'm following your argument, is your contention in essence that the Leandro line of cases is just irrelevant to this, to the claim that you're asking us to recognize?
I think that's mostly correct, Your Honor. I think that the right.
How is it not? To the extent that it's not correct, how is it not correct?
I think it's almost virtually entirely correct. I think that there has sometimes been dicta in some of those cases that might speak to access. I think Leandro itself is helpful because it distinguishes Snead. In that case, in Leandro, when it was at the Court of Appeals, the Court of Appeals held there's no qualitative aspect to the educational right that's at issue. The only aspect is the access aspect. And this court reversed. It said this is not a Snead case. This is a case about what kind of education you have a right to access. In this case, the opposite error was made by the Court of Appeals. The Court of Appeals held that the sum total of your educational rights are the Leandro rights. It's only about the qualitative aspect. But of course, the majority below ignored Snead. It didn't cite to Snead at all. It certainly didn't recognize the distinction that this court drew in Leandro between the right asserted in Leandro and the access right that's being asserted in this case. Here, but because Leandro is not the answer to any of the questions in this case, the Pitt County Board of Education is the proper defendant because it is the party that's responsible for denying the Deminski children access to an education. It's also important to note that we actually did sue the State Board of Education. They were a defendant in this case. They moved to dismiss. The trial court dismissed them, and we've never had an opportunity to appeal their dismissal. Second, the board on the appeal also argues that the educational rights that are protected by the state constitution are merely curricular. And this is what I was just speaking with Justice Irvin about. The school board is arguing that there's a collective right to a good curriculum being taught in the public schools, but it doesn't actually matter whether any child can access it. But I think that the greatest problem with the school board's arguments are the mischief that they would allow. Under the school board's arguments.
Before Mr. Shelton, before you go to that point, again, I'm trying to go through this step by step kind of logically in my own mind. I mean, Snead involved a policy by the local board. King, which appears to be the other case that you place principal reliance on, also involved in action by a local board. Here, if I'm understanding your claim correctly, what you got is in essence a claim that the board, instead of taking affirmative action itself, was deliberately indifferent to the conduct of others. The two seem to me to be somewhat different, at least. Why should the access claim reach the kind of conduct that we've got here?
But ultimately, in this case, Your Honor, we're not trying to hold the school board liable for the conduct of third parties. We're trying to hold the school board liable for its own decision to stand by and watch child abuse and do nothing about it.
Well,
so the second,
and that answer may get to a question I was going to ask anyway, but let me go ahead and ask it now. You obviously are placing principal reliance for your remedy on a damage claim. What damages would be recoverable if your claim were to succeed in your view?
I think part of the damages that would be, well, in general, the damages that are needed are the damages to restore the access and put the children back in the place that they would have been in had the access never been denied. So one of the children,
I'm sorry, measured by educational attainments. I mean, how do you put them back in the position that they would have been?
Yes, so Your Honor, so one of the children has had to seek psychological counseling. So any out-of-pocket calls for the psychological counseling, to the extent that the Deminskis have had to pay for tutoring or any other kind of extra lessons, then those would all be the types of damages that we're seeking. We're not calling this this is not a personal injury claim in the sense of pain and suffering damages. The injury is tied to the substantive. The remedy is tied to the substantive right, and here the substantive right is access to an education. So the damages are needed to restore that access. And so at the second step of our argument, Your Honor, is once it's acknowledged as a general matter that a local school board can be held liable for denying access, the question is whether under the facts of a case like this, the injuries that occurred are fairly attributable to the school. And we've proposed the deliberate indifference standard for doing just that. To evaluate whether, to back up for just a moment, I think it's worth noting that the school board doesn't actually seem to quibble with the deliberate indifference standard. And I think that that makes sense because the school board has been subjected to the deliberate indifference standard for over 2 decades under federal law. The federal standard prohibits local school boards from being deliberately indifferent to peer abuse based on a suspect classification such as sex, race, or disability. Now, the board's amicus in this case has suggested that the sky would fall out if the court were to adopt that same standard. There's no reason to believe that that's so. In fact, the dissent in the Davis case, which adopted this in the Title IX context at the U.S. Supreme Court, predicted the same thing. But we haven't seen the sky fall out in the past 2 decades. Essentially, the school board has made an empirical claim, but they haven't backed it up with any case law that would show that kind of injury has occurred. So our proposal of the deliberate indifference standard is really just a request for a marginal extension of liability against the school board, because much of the abuse that occurs in the schools already probably is based on suspect classification, such as disability, race, or sex. And opposing the standard under the state constitution is actually much less burdensome than implying the standard under the federal statutes, because the violations of federal law are backed up with attorney's fees. But a quorum claim, like our claim, there's no fees available for a prevailing plaintiff. Thus, a state constitutional claim is only going to be brought in the most egregious circumstances, because only in a case like that would the injury actually be worth an attorney's time. And it's also important that the application of the standard is workable and, in fact, very straightforward in this case. There are 3 elements. The first element is abuse that is so severe that access to an education is effectively denied. And that's what's pleaded in the complaint in this case. The Deminski children suffered severe abuse from their peers at school, emotionally, sexually, physically, and that abuse caused their academic performance to plummet, which shows a denial of access. At step 2, the school board had actual notice. The school knew about the abuse that was going on because Ashley Deminski told everyone, all the way from the teacher to the principal, about the abuse. And finally, at the third element, there was an unreasonable response. After the school learned about the abuse, it sat on its hands. But the school had both the duty and the opportunity to stop the harm. When a school has actual notice of outrageous child abuse happening in its school, doing nothing is always an unreasonable response. Now, I think that the unreasonableness of the response is easy to look at in this case, but I think that there are several factors in other cases that the court could look at. For example, the court could look at the severity of the harm that's alleged, the likelihood of the harm recurring, the duration of the time between the school board's notice and the response from the school, the thoroughness of any investigation that the school board undertakes, and any provisional steps that the court takes along the way to protect the victims during the investigation. Finally, Your Honors, the school board has made an argument about adequate state remedies. As we noted in our brief, we don't believe that the court should consider that extremely untimely argument. The school board had the opportunity to raise that defense at the trial court, and it didn't do so. It had the opportunity to raise it before the Court of Appeals, chose not to do so there either. When we filed our PDR, they could have added that as an issue in their response, and they didn't do it then either. So it would be highly unusual.
Mr. Shelton, if we were to accept your agreement, your argument, decline to look at this question and then allow the case to go back down for discovery and trial, would that argument could be raised at a later time?
That's exactly right, Your Honor. There's nothing stopping that.
But is there any reason in theory why, since we've got this case before us, we shouldn't look at the total scope of what a claim of this nature would look like? I mean, at one point when you were in your brief, you suggested that we go ahead and reach the merits, even if we were to agree with you on the appealability issue. I mean, wouldn't the same logic apply with respect to this particular issue?
Well, I think that the issues that I suggested that the court raised were in fact properly before the court. And that's the difference between this defense that no court below has ever looked at. Essentially, the court is asking this court to be, the school board is asking this court to be a court of first view, not a court of review, which would be certainly out of this court's usual practice. But even if this court were to engage the argument, I don't think that it has any merit. So I don't think it would be particularly difficult for the court to swat it away. For a remedy to be adequate, it must actually exist. Nowhere does the board seem to contest the fact that what we're seeking are damages and injunctive relief, but they've nowhere showed how the statute would allow either types of those relief. What this statute actually is a procedural statute for an appeal process. But we don't have a procedural injury, Your Honor. We have a substantive injury. It's also worth.
So is your argument then that an alternative remedy for purposes of a quorum claim has to include damages?
No, Your Honor. In quorum itself, this court held, it actually refused to decide what remedy would be available. It did hold that damages could be available for a quorum claim. It also held that injunctive relief could be available for a quorum claim or some combination of the two. Quorum was actually a First Amendment claim, but it was really an employment case. So the court held that the employee that had been retaliated against could be entitled to lost wages, or he could be entitled to reinstatement of the position that he lost in that case. And so I think that it is, certainly either remedy could be available. After quorum, I think that litigants typically treat quorum claims as claims for damages, but of course, there's a full panoply of options, which is what quorum was saying. The last argument, Your Honor, I'd like to note, because we put it before the court, we don't believe that the board should actually have ever been allowed to appeal from the denial of its motion to dismiss. Like Justice Ervin said, we do believe that the court should take the opportunity to address both appealability and the merits, but I also would like to separately address the appealability. Justice Ervin, I don't want to step, I feel like you're trying to ask me a question.
Yep, go right ahead.
Oh, I'm sorry. So the interlocutory order in this case could not have affected a substantial right. This court plainly held in Craig that there is no sovereign immunity available to a direct claim under the state constitution. And the facts of this case are identical, or virtually identical, if not worse than the facts that were pleaded in Craig. And the court in Craig did not need to determine whether the constitutional right actually existed in order to reject the immunity defense. After Craig in Sandhill, this court, adopting Justice Ervin's opinion dissent from the Court of Appeals, emphasized that the merits of a claim and the grounds for appealability are entirely separate inquiries. Here, however, the board would fuse those inquiries by having the court first answer the merits question, then answer the immunity question, and then back that up into a question of appellate jurisdiction. That is exactly the opposite of the holding of Sandhill. And what the board is really after in this case is a policy argument. The board is saying they don't think that they should have to litigate a constitutional claim until an appellate court has told them what the contours are of the right that's being asserted. And the board was welcome to file a petition for a writ of certiorari at the Court of Appeals to try and put that kind of discretionary argument to the court, but it didn't do so. What instead it tried to do was hang its hat on a substantial right to an immunity defense that simply didn't exist. If there are no other questions, Your Honors, I would reserve the balance of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Thank you, Chief Justice, and may it please the court. I'm Deborah Stagner, appearing on behalf of the Pitt County Board of Education, along with my co-counsel, Mr. Spies. I will begin by taking up the issue of appellate jurisdiction before addressing the plaintiff's failure to state a direct constitutional claim under the education clauses of our North Carolina Constitution. Mr. Spies will then address the quorum argument and whether the plaintiffs have an adequate state remedy under GS 115C-45. First, I'd like to acknowledge that the facts that are alleged in plaintiff's complaint are appalling. And it is not the position of the Board of Education that a student must endure a chaotic, violent, or dangerous classroom environment without any recourse or remedy. But this court has never held that an individual student has a claim for money damages directly under the state constitution based on a local Board of Education's failure to provide the opportunity to receive a sound basic education. And this court should not do so in this case. The Court of Appeals decision in this case is entirely consistent with the prior decisions of this court, and the Court of Appeals decision can be affirmed in favor of the board without disregarding this court's established jurisprudence. And that includes the case of Craig versus New Hanover County Board of Education. The plaintiffs have argued that the Court of Appeals lacked appellate jurisdiction over this case because of the court's decision in Craig, and that the analysis should end there. But plaintiffs read Craig too broadly. In the decision's very first paragraph, Justice Hudson lays out for the court the sole question that was faced in Craig, which was whether the plaintiff's common law negligence claim, which would ultimately be defeated by governmental immunity because of its exclusion from the board's insurance coverage, provides an adequate remedy at state law. And this court unanimously held that a common law negligence claim that was defeated by governmental immunity did not provide an adequate remedy to a, quote, colorable constitutional claim. But the holding in Craig went no further than that. Later in the decision, in fact, the court specifically warned that, quote, its holding does not predetermine the likelihood that plaintiff will win other pretrial motions, defeat affirmative defenses, or ultimately succeed on the merits of his case. In plaintiff's view of Craig, the word colorable is made to carry a lot of weight, but I would argue that this court, having so very carefully fleshed out the scope and meaning of our state constitution's right to a sound basic education, both in Leandro and in his progeny, that this court would not dramatically enlarge that right in Craig without discussion or analysis and would not rely on the single word colorable to do that work. As then Judge and now Justice Irvin explained in the Doe versus Charlotte Mecklenburg Board of Education decision, the question is whether Craig contains a single holding that is barred, a single holding relating to the extent to which the existence of a common law claim that is barred by the doctrine of governmental immunity precludes the assertion of a constitutionally based claim, or whether Craig implicitly addressed substantive constitutional issues as well. And so
let's say that there was a student who, for whatever reason, was prohibited to attend a school. And it was not a behavioral issue. It was just, student, you can't come here. What would be the remedy of that student, if any?
So I think in that case where a school board took action, affirmative action to bar a student from the schoolhouse doors, so to speak, that the remedy would be found under a Snead or a King analysis. And those are cases where the Board of Education did actually deny the opportunity to obtain an education by locking the schoolhouse doors, so to speak, and keeping the student out of school. And so that is not the case that this plaintiff has brought, but there certainly could be a case or could be a claim that certainly schools are allowed to keeps students out of school for expulsions or suspensions that are conducted in accordance with due process. But Snead and King were both due process cases that that looked at the boards and the school board defendants' affirmative conduct in barring the children from school.
Let's say it was a 7-year-old, 8-year-old boy. He rode the school bus, and every day for a couple of days, he was assaulted on the school bus to the extent that he wouldn't get back on the school bus. It was made known to the school administrators, the school board, that this little boy was physically assaulted every day and was not able to get on the school bus because of his fear. Is that a claim if the school board did nothing?
Well, Your Honor, I certainly wouldn't say that the student had no claim, but the question that this court must decide is whether there is a constitutional claim, a direct constitutional claim under our education clauses in Article 1, Section 15 and Article 9, Section 2, that would allow that student to bring a claim directly under the state constitution for damages when, as Mr. Spies will cover, there are other available remedies, and certainly by, in this case, Mr. Shelton has noted that Title IX is a claim. Certainly there are tort claims against individual school employees who may be negligent. So it is not as though a student or family is without relief or remedy. It's that this particular remedy that is being sought in this case is not appropriate. And I think I would urge the court to affirm the Court of Appeals decision in this case, because Justice Ervin's analysis in the Doe case was correct, and the Court of Appeals below was correct to rely on Doe. That Craig said nothing about the extent, if any, to which the plaintiff had stated a viable claim for relief under the Constitution.
Ms. Stagner,
yes.
I'm sorry if I may. Does the North Carolina Constitution grant students a property right to a sound basic education?
I don't think that this court has answered that question, and I would say that it does not. That the Leandro line of cases, I mean, you could certainly say that there is a right on an individual student to have the opportunity to receive a sound basic education. There is no guarantee of ensuring that student actually does obtain a sound basic education. The right to access is the right that is set out in Snead and King of a due process right to have that affirmative obligation of the state to provide a sound basic education to every student in every district in the state. It's a right to have access to that system of education that meets minimum qualitative standards. I hope, does that answer your question, Your Honor?
Thank you.
Let me jump in and ask you. I thought you were going to explain about the appellate jurisdiction of this claim, and so I'm wondering if you could address that specifically. What is it about this this case that allows an interlocutory appeal of this order?
Yes, thank you, Justice Hudson. I was just going to get to that. So the Doe decision then went on to further explain why appellate jurisdiction was appropriate in this case. And I'm not sure that I can articulate it any more clearly than Justice Ervin did in the Doe case on page 364 and 365 of that decision. But governmental immunity is a substantial right that entitles the defendant to an immediate appeal, because if the case is allowed to proceed to trial, the immunity is effectively lost. And assuming, as we would assert, that there is no cause of action recognized in Craig, that the mere fact that the plaintiff has asserted certain of her claims are constitutional in nature doesn't automatically mean that she stated one or more valid constitutional claims, or that the board is not entitled to avoid liability with respect to those claims, quote, properly understood on governmental immunity grounds. So the case is immediately appealable because the plaintiff has immunity is part of the analysis of whether there is a alternative available state remedy. By pleading only a constitutional claim, the plaintiffs have denied the Board of Education the opportunity to show that there is immunity, and has taken away and bypassed that potential defense of immunity. Granted, no guarantee that that immunity defense would be successful at the trial court, but.
Well, I'm just, I'm looking at the answer and defenses, and the only thing I see about immunity is sort of a mysterious paragraph about the seventh defense, which makes reference to the defense of immunity is specifically asserted to the extent the insured, and I assume that's referring to the school board, is not indemnified by liability insurance as provided in NC Gen Stat 115C-42. And I'm just wondering where in the complaint is the kind of immunity that you're referring to in your argument that would make this appealable on an interlocutory basis.
So, Your Honor, the plaintiffs have argued that there's no immunity to a constitutional claim, and that's correct. Under Quorum and under Craig, there's no immunity to a constitutional claim. And the board hasn't argued that there is immunity to a constitutional claim. But in Doe, the plaintiff pled tort claims in addition to constitutional violations, and those tort claims were barred by governmental immunity. So the plaintiff then had an opportunity to present her constitutional claims and obtain a determination about whether those claims had any merit. In this case, the plaintiffs did not assert any tort claims. They didn't allege or plead that there was an alternate available state remedy. They've simply pled a constitutional claim that arises from facts that would state a tort claim. And so by circumventing, by calling it a constitutional claim and clothing it in constitutional language, when really it is only a tort claim that they have pled, and they haven't pled a waiver of immunity. They haven't pled that there's an alternate available remedy for their constitutional claim, that the plaintiffs really are putting a constitutional claim or a tort claim in other clothes in the name of a constitutional argument. And again, I would point this court to Justice Ervin's opinion in the Doe case and the analysis of why you cannot simply call something a constitutional claim when no such claim has been found, and thereby withdraw from the Board of Education the opportunity to even make the argument about immunity and to present its immunity defense. If then the case had to be tried, the Board of Education would have lost that substantial right, which is to avoid a trial on the basis of its governmental immunity.
So I'm not entirely sure I'm following, but so are you saying that even though they've alleged just a straight up constitutional claim, that we should interpret it not as that, but as in essence a tort claim, and infer that there should be immunity available, and therefore we should address this on an interlocutory basis? No, Your Honor, they have called their claim a constitutional claim, and it's our argument, as I will hopefully get to in the substantive part of this argument, but we have argued in our brief, this court has never recognized a constitutional claim such as the one that plaintiffs are asserting. The court has never recognized, neither the Court of Appeals nor this court has ever recognized a private cause of action for an individual student for money damages based on the abuse or improper conduct of a third party in a school setting. And so what the plaintiffs are attempting to do is to take that type of a claim, which really sounds in tort, and call it a constitutional claim without, again, pleading that there is, if you look in the complaint, there is no allegation whatsoever
that there was an available state remedy, and therefore by circumventing the whole process of allowing the opportunity to have the immunity decided, that is the reason that this court and the Court of Appeals and this court have appellate jurisdiction.
But
I think Justice Earls has tried to get in, so I will stop. Go ahead, Justice.
I'm sorry, please. I just want to follow up because my question is on this point. And that is, I understand your argument about the limitations of what Craig decided, but didn't Craig at a minimum decide that because there was not essentially applying quorum in factual circumstances very similar to this one? I understand that you're saying there's a difference between deciding whether sovereign immunity applies for a colorable claim and deciding whether that claim itself is actionable. But Craig decided something, and it seems to me what it decided was that in circumstances like Craig, which is this case, there is a colorable claim that can proceed, and that if your argument is, well, they haven't stated a claim for relief under the Constitution, that's every 12b6 motion. They haven't stated a claim for relief. It seems to me the immunity question has already been decided, and you can bring your 12b6 and you can appeal it if you lose, but I don't understand why you get to sort of two bites at the apple on the sovereign immunity issue.
Well, Your Honor, thank you for that question. In fact, in in Craig, there were tort claims brought. The immunity issue was decided because the board had insurance and had waived its immunity, or did not have insurance and had not waived immunity. So there was no coverage. So there was no the immunity barred the relief, and that was really the essence of the Craig holding, is that because the board had immunity to the state law tort claims, there was no adequate available remedy under state law. In this case, the board never had an opportunity to demonstrate whether or not it had immunity. There was never any opportunity for the board to assert its immunity defense, and plaintiffs in this case seem to assume that the claims would be barred by sovereign immunity, and certainly the board should have an opportunity to make that argument. But by not pleading or including in the complaint that there was a lack of an available alternate state remedy that was adequate, that entire analysis has been bypassed, and the plaintiffs are moving directly to whether or not there is a substantive constitutional claim. And so,
well, I know you want to move on, but you've talked a lot about Doe, and I just want to understand the plaintiffs distinguished Doe on the grounds that in Doe, the allegation was mere negligence, and here they're alleging deliberate indifference. And are you saying that makes no difference?
Your Honor, it doesn't for the appealability question, because the board is entitled to assert governmental immunity for cases that are not just negligence cases, but cases that sound in tort, any sort of case in tort, so long as there is not a waiver, and the state statutes on that allow a Board of Education to waive its immunity by the purchase of insurance. So the nature of the tort claim isn't, I believe, an important distinction in this case. So just so that I don't run out of time, and I'll be glad to answer any other questions on that, but I would like to at least move on and touch on the substantive issue as well. And in fact, plaintiffs have invited the court to go ahead and reach the merits of this case, even in the absence of jurisdiction under the immediate appeal. And as your honors are well aware, the appeal in this case is before the court on Judge Zachary's dissent in the Court of Appeals. And although we would disagree with Judge Zachary's conclusion that a claim alleging a violation of the constitutional right to an education can be grounded in tort, she explicitly framed plaintiff's claim as a Leandro quality of education claim. And I would point the court to the very first paragraph of the dissent, which states that the right to an education set forth in the North Carolina Constitution requires that our state's educational entities provide the students with an education that meets a certain minimum standard of quality. And because the facts alleged in plaintiff's complaint established that defendant failed to provide the minor plaintiffs with the constitutionally adequate quality of education, Justice Zachary dissented. The plaintiffs did not submit a brief or argue any legal theory at the Court of Appeals, but now before this court, the plaintiffs argue that this is not a Leandro case, and plaintiffs' counsel reiterated that just in his argument today. They say that this is not a Leandro case, even though their own complaint cites Leandro and cites the two specific provisions of the North Carolina Constitution that were interpreted by this court in Leandro. That's Article 1, Section 15, and Article 9, Section 2. The plaintiffs attempt to change the narrative from what Judge Zachary's dissent argued, which is what brought the case to this court. So they attempted to change the narrative and argue that this case is about access to education and not quality of education, but that's precisely how the question was framed below. The plaintiffs, again, rely on two cases from this court, Snead versus Greensboro City Board of Education and King versus Beaufort County Board of Education. But the Snead and the King cases do not require a ruling in the plaintiff's favor. In both of those cases, as has been discussed earlier.
What do you, I mean, assuming that we are not to agree with you that we don't get to this access question, what kind of claim, in your view, do King and Snead recognize? What is a viable access claim?
Well, Your Honor, in both of those cases, the school board defendant took some action or made some decision to deny the plaintiffs access to an education. The defendants literally closed the schoolhouse doors to the plaintiffs in both cases. In Snead, because of a fee policy that prevented them from re-enrolling, and in King, because of disciplinary suspensions and exclusion from an alternative education. And in this case, the plaintiffs were not excluded from school by affirmative conduct of the board. And to take plaintiffs' own example, they were not locked in a closet and prevented from attending class. So the access claim.
If I understand Mr. Shelton's argument, though, he's saying that there's no difference between locking them in the closet or barring them from attending and a situation in which your clients allegedly knew about things that were basically precluding the client's children from getting education, and that there's really no difference between the two in any meaningful sense. I think that's his argument. What's your response to it?
Well, Justice Irvin, my response would be that in Snead and King, there was a literal denial. In this case, again, going back to the language of the dissent, this is about the quality of the education that the students received. It's not about the fact that they were not, there's no allegation that they were barred from school. There's no allegation that they were kept from the classroom. This is about the quality of education that some individual students received in an individual classroom, and whether or not this court or any of our courts in North Carolina are going to get into the business of determining whether that chaotic classroom environment was substantially or was a substantial interference or denial of education sufficient to raise it to the level of a constitutional wrong. And I do want to give Mr. Spies an opportunity to get to his argument. So I will stop there, Your Honor, and let him go forward.
School, and I should unmute myself soon, shouldn't I?
And we can hear you, Mr. Spies.
Okay. Good afternoon. I'm delighted to be here along with Ms. Stagner to represent the Pitt County School Board. Let me get right to this. I think this case is about the limitations on quorum claims that this court spelled out in the quorum decision. There are two real limitations. One is whether there are existing remedies that the court ought to defer to and allow to take place. And I believe, as we've described in our brief, the 2001 amendments to GS 115C 45 substantially expanded the right of parents to present concerns to school boards about the education of those children, of their children. The opportunity to do so under that statute can be based upon a violation of any specified federal or state law or any state or local policy or rule. And it's clear from the complaint in this case itself that there are statutes and there are rules on the books, that specific statutes that apply in circumstances like this, including the School Protection Act, which was specifically alleged as a separate claim in the complaint. But I think the more important issue here in some respects is this. The other limitation on the court's power to recognize a quorum claim is the court's obligation to respect the duties and responsibilities of the other branches of government. And one thing, a couple of things are crystal clear from the Leandro cases and the Hope County cases, and indeed all the cases dealing with education. And that is that the responsibility for providing the opportunity for a sound basic education rests principally with the General Assembly and with the State Board of Education. And in Leandro and Hope County, it's clear that the way to that path is principally through the creation of a uniform system of free public schools where all children will have an equal opportunity for an education. Sometimes, unfortunately, in the best of systems, kids fall through the cracks. And 115C45 is the part of the state's uniform system of education that covers those circumstances. 115C45 applies in every county, to all 117 school boards, and to every parent. And when something happens and a child is falling through the cracks, the court, I believe, is duty-bound itself to honor the legislature's determination that those situations should be taken care of under this statute. The plaintiffs did not do that here. I believe the court's cases establish that where you believe that the remedy is not adequate, you are obligated to plead that and to plead that the remedy is not adequate. That did not happen in this case. I believe this court's decisions are clear that the failure to exhaust an administrative remedy is a failure of subject matter jurisdiction, which can be raised at any time, at any point, even on appeal. So we think, Your Honors, that the quorum exceptions, the limitations on quorum clearly apply in this case. The plaintiffs did not honor those or take advantage of those opportunities. They have not pled that those opportunities are not adequate. So I believe their complaint should be dismissed. Now they say, and I think this is what this case is really about, we shouldn't have to go through 115C45 because we can't get damages. Well, I don't believe this court's cases established that damages are one of the necessary remedies in a particular case. In the Craig case, the court said, what you need is access to the courtroom. Well, 115C45 provides access to the courtroom. In quorum, the court said, you know, there's these questions of what is the particular appropriate remedy for a particular problem depends upon the right violated in the circumstances. And furthermore, Your Honors, I would just end on this.
Mr. Spees, I'm sorry, your time has expired.
Thank you, Your Honor.
Thank you, counsel. Rebuttal.
Thank you, Mr. Chief Justice. Several points. First, this was the first time that I had heard from the school board a concession that they can be held liable as a local school board for an access denial. It seemed to me that they had taken the opposite position in their brief. So I think that really the key question in this court, for this court, is whether our standard fairly holds them accountable for the decision that they made to stand by and do nothing when child abuse was going on in the schoolhouse. The next point I want to make is the school board also seems to have an argument that there's no such thing as an individual right to any of the educational provisions. This court has said the exact opposite in Hope County, sometimes called Leandro 2, and also said the opposite in King. Next, Mr. Chief Justice, in your bus hypothetical that you posed, we do believe that there could be a claim there. Once there's a special relationship, once the school has control over both the abuser and the abused, the school has a duty to protect the student. So if there's violence that's happening in that type of scenario, background tort principles help answer the question. Mr. Chief Justice, for example, your opinion in Stein versus Asheville Board of Education discussed a situation looking for whether there was a special relationship. And that same principle, which is the principle that's also in the second restatement of torts, section 320, is what we've hung our hat on, is what the U.S. Supreme Court hung its hat on in the Davis opinion. Mr. Justice Berger, you asked whether educational rights or a right to an education has ever been held to be a property right. I don't have an answer currently for you under our state constitution, but the answer to your question under the federal constitution is a yes. And Goss versus Lopez, which is at 419 U.S. 565, the U.S. Supreme Court has already answered that question with a yes. What's very concerning in a case like this is that the government is on the one hand compelling students to attend school, and then on the other hand failing to protect them when they're there. The school is essentially standing in loco parentis once the children are in the schoolhouse and owes them a duty to protect them because there is no one else there to protect them except for the school. And finally, Your Honor, Mr. Spees in his argument discussed the School Violence Prevention Act. We don't believe that is an alternative remedy. As he noted, there's not really even a private cause of action under that statute, and we included it in our complaint. It was dismissed by the trial court, probably properly, because it's not an adequate, it's not a remedy at all. It's also helpful if we're going to look at the School Violence Prevention Act, and under Mr. Spees' argument, this alternative remedies issue is a matter of respect for other branches of government. But if you look at section 115C-407-18, the General Assembly says how it wants this court to construe the School Violence Prevention Act. And it says that this article shall not be interpreted to prevent a victim of bullying or harassing behavior from seeking redress under any other available law, either civil or criminal. And it also says that nothing in the School Violence Prevention Act, this is subsection C, should be construed to require an exhaustion of the administrative complaint process before other remedies may be pursued regarding bullying or harassing behavior. Mr. Spees also identified other pleading failures today that he sees in our complaint, but those are arguments that the school board can make on remand. They can file a 12C motion and a complaint can be amended if it's simply a matter of adding a few words to the complaint. And ultimately, the only remedy that's been identified is 115C-45. That's the remedy that the school board wanted this court to look at when it filed its brief. But there is no mention of a remedy in there. There is nothing about damages. There is nothing about injunctive relief. There is nothing about any kind of relief at all under that statute. Ultimately, Your Honors, the state constitution promises that our children will have a right to access a public education on the same terms as all other children. And that promise is not an empty one. It's not a promise, as the board has sometimes suggested, that local schools can break with impunity. Ultimately, for educational access to mean anything, children need a safe place to learn, and schools can't deny that access by knowingly tolerating child abuse. That is not the kind of promise that North Carolinians enshrined in their state constitution. Thank you.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is in recess until 9:30 tomorrow morning. God save the state and this honorable court.